Good morning, everyone. Good morning to you all. Welcome to the Aurum podcast, where we discuss all matters in HR and how to build winning teams. I'm your host. My name is Anthony Kuria, and this podcast is hosted by Aurum Consultants Limited, a HR and risk advisory consulting firm. And here at Aram Consultants, we do everything that relates to human resources. And as I said earlier, how to build winning teams. Now, today, we have another, I believe it's a blockbuster team that we are with here. First of all, as you've seen here, there is Martha Thuku. Martha is the consultant. She comes here to help us unravel issues regarding HR. So Martha, karibu sana.
Thank you, Anthony, and welcome, viewers.
Yes, and also with us. Unfortunately, there is a bit of a problem with his technical issues, the issues with camera, but it does not mean that he is anyway encumbered. Today we have a guest from the legal fraternity. His name is Perry Kegode, uh, an advocate with Agimba and Associate Advocates. Perry, karibu sana.
Thank you very much, Anthony Kuria, and apologies, guys.
Sawa sawa. It happens, but I can assure you, our listeners and viewers, this is just a hiccup. It does not mean that what we are about to speak about will be in any way hindered or encumbered,
I
because knowledge
agree.
cannot be hindered because there is no camera or anything
There
like
is,
that.
I agree.
Now,
I agree.
indeed, Perry. Now,
Yeah.
this month, in this podcast, this month of February, we've been discussing all matters regarding contracts, especially as they regard to the HR space, the human resource space, contracts between employers and employees. And today we want to discuss contract termination. Siku imefika, we want to shake hands and say it's been real. Thank you for being with us. But now, time to go our separate ways. But as you all know, contract terminations not only have legal implications, they also have emotional implications. It's not very easy to, both for the employer and employee, to feel like shaking hands and saying it's time to separate. For the employer, there is a feeling like, okay, they have found greener pastures somewhere. We are not good enough for that person. They have decided they no longer want to work with this company. As an employer, as an individual, nobody likes to be rejected. Okay? So from an employer's perspective, a good employee might decide to go. From an employee's perspective, the feeling is like, okay, I'm not good enough for these people. They have decided they don't want me, or my skills are not good enough for them. So it is contract termination can be it has both psychological, emotional, and legal implications. And as before I go too far, it's good to define what it is all about, to define it well. When I was preparing for this podcast, this is what I came about with. That contract termination refers to the legally ending a contract prior to it being fully performed by the parties. The termination of contracts can be caused by several factors, but not including but not limited to a breach of contract. So the question I had for myself is, how do you handle this process without having to resort to litigation? That's where we are today. That's what we are discussing. That's our frame of mind. We don't want to go. We don't want to start discussing what Mr. Kegode, what they do when they now when they now go into
Into
now we are, yeah.
the legal
I'm sure
aspect of it.
exactly, Perry. I'm sure you can tell us if we were to give you a chance, you'll tell us how it happens when it goes
Definitely.
to the law courts.
And it's actually messy.
Exactly, exactly. Now, Martha, now that we have divided what we are talking about, that we handle this process without resorting to legal, without resorting to litigation, my question is, Martha, from your HR perspective, and then I'll ask Perry to to throw in his perspective. What are some of the reasons for contracts being terminated?
Okay. Good morning, everyone, and thanks, Anthony. So even as we come to this question, first, I like doing this. I like introducing my organization where I work,
Okay,
because
go
we
ahead.
do very interesting things, especially beneficial to the community and to our social areas, to the community in Kenya as a whole. So I work with LVCT Health, and in LVCT Health, among the various many things, it's a very dynamic organization. But among the various things we do, we are the lead in matters mental health and GBV. So for those organizations who need their staff counseled, counseling, and everything that relates to mental health, stress management, everything. And right now we have even included, there's this issue of safeguarding that has come, and we are also training on that. And so we are very big in these trainings, and we welcome you to just reach out to LVCT Health, either through our website. You'll go there and you'll get our contacts, and we will connect you to the right people where you can say what your need is, and we will address it. And you can reach me through the Oram podcasts. They will be displaying their contacts, and you will reach me, and I can be able to guide you how to go about it. Thank you so much. So today we are talking about matters contracts termination without going to litigation. That's
Yes,
what Tony will say there.
yes,
So,
that's true.
viewers, we have
Yes.
seen from before, we defined what a contract is, and we realize it's a legally binding agreement between two people. And for an employer and employee, it's really that document that details what you are going to do in that organization, where you sign and the employer signs. And today I'm so happy because we have a lawyer. So for me, I reach out to lawyers a lot to just gain understanding, to make sure that we are in the right track. But let's
Sure.
talk about today's topic. Why? Did you ask reasons why contracts are terminated?
Yes,
There are
reasons why
various
contract.
reasons,
Yes.
especially from an employer-employee perspective. There could be various reasons. Some are not good, because then you can terminate a contract for someone defying or going against that contract that you already agreed on, doing things that could harm the organization. Some could be
Yes.
even lack of performance. Some could be violating the agreed uh, things in that contract.
Okay.
There are some
Yes.
organizations who have things they call zero tolerance policies. Violating those policies, you'll find
Yes.
some of those policies have to do with the way you conduct yourself at the workplace. So you could be a very good worker, you're achieving your targets, and then you find the discussions you're having regarding your termination has nothing to do with your work, but has to do with your conduct. And
Okay.
they are spelled out. Most of the time I find myself, when I'm in such a situation, I find myself finding the employee's defense is the targets he has met for the organization. The defense is how much he has achieved for the organization, the benefits, or whatever it is that they have done for the organization. And in this discussion, we are not talking about the what you have done, it's the how you have been doing it. And you could have been violating the rights of people you are working with. You could be sexually molesting them. You could be even just many areas. You could be fraudulent. You are doing things. You are stealing organization money, and maybe you're not known. You don't think that people are knowing because maybe you could be a leader somewhere or something. And this doesn't happen also in leadership only. It happens in various areas of the employee. You could be
Yes.
there, and you are an organization that rely on data, and you are cooking data to look like you are performing, and so many things that relate to integrity. So
Yes.
such are the things that can make a contract be terminated. There are some in the Employment Act, and they are detailed there. So there are some like coming to the office intoxicated, falsifying office records, some those kind of misconduct I have talked to about. I talked about poor performance, and there's something else they call damaging organization property. If you go to the Employment Act as an employer, you'll find them that they are detailed there, and those are really things that amount to summary dismissal. Then some other things I can mention is redundancy. So you have a contract running, and maybe the organization has lost funds, they're not able to pay you anymore. So a contract that is running can also be terminated due to that. We find this a lot in the NGO sector where I'm at, because then there's the donor funding. Like the last few years, you find the donor promised you so many millions for the 5-year project. But every year, that money, they release money annually. And you find that
Yes.
they have that money has reduced. The following year, the targets are the
Yes.
same, but the funding has reduced. If you are to get 1 million, then you find you're getting 700,000. And then the next year you get 500,000. So every time they reduce that money, then some people's contracts have to go because there is no money to pay them. So those are some of the areas. Then there is retirement. Is retirement There is retirement, and also there is resignation when a staff just also decides they have seen greener pastures, so they also resign. Those are some of the areas contracts get terminated. And I can see Zipporah has joined us. Welcome, Zippy, and you can add to what I was talking about. Thank you.
Wow,
Thank you.
wow,
Thank you,
wow.
Mother.
Yeah.
Yes, thank you, Martha. You have really, you know, dissected, briefly but comprehensively the various areas where the various reasons why contracts are terminated and all that. Perry, from your perspective as an advocate, from a legal perspective,
Yes.
what would you add concerning termination of contracts, especially in the employment, from the employee-employer perspective?
Yes. Thank you very much, Thuku. And that was a very, very comprehensive statement and dissection that was done by Zipporah.
Yes.
Yes, and I'll just briefly go to the areas because from an HR's perspective,
Yes.
there are various depending on the nature of the engagement. The
Yes.
Employment Act has provided for the steps and
Yes.
the provision, sort of like the channel that you're supposed to use, so that,
Okay.
for example, us as litigators, when we go to court,
Yes.
we wonder why the Employment and Labor Relations Court
Yes.
always people have the perception that it sides with the employee more often
Uh-huh.
than not, because you'll
Uh-huh.
wonder, you'll say, the claimant has taken me to court.
Mm-hmm.
The reason for his or her termination was disciplinary in nature. He comes to
Mm-hmm.
work late. He comes to
Mm-hmm.
work intoxicated, and
Mm-hmm.
we dismissed him. But we are wondering why the court is siding with with the employee. So
Mm-hmm.
this is where the now the interpretation of the Employment Act comes into place. We have
Mm-hmm.
to appreciate one thing that is always a doctrine of the law. A process is more fundamental and important
Mm-hmm.
as in determining the outcome. So that,
Ah.
for example, the Employment Act, I'll just quickly go through the termination due to disciplinary issues.
Mm-hmm.
Section 45 of the Employment Act, it says that there is a process that has to be followed. So that if I
Mm-hmm.
come to work late today, I
Mm-hmm.
come to work late tomorrow, and
Mm-hmm.
then you fire me, or I come to work intoxicated and then
Mm-hmm.
you fire me, that is going to be considered as unprocedural. So that the court,
Mm.
it won't matter whether or not I came to work late or whether I was intoxicated in work. The court will
Mm.
just will be interested in, did you offer the employee the due process or the mechanisms, were they strictly adhered to as is provided in
Mm.
section 45 and 42 of the Employment Act? So that, for
Mm.
example, how you're going to handle that
Mhm.
is, if it's a question about disciplinary, the law says that you have to give the employee a notice to show cause. You have to
Mhm.
give me, first of all, not really a warning letter, because I see a lot of companies just write warning letters, and then before you know it, you have a dismissal letter. You find it on
Mm.
your desk. I'm telling you, you will pay. So basically, what you have to do is you write to me a show cause letter, and
Mhm.
then you give me an opportunity. You have to accord me what we call a hearing, so that
Mhm.
basically the management of the company, it can be the HR,
Mhm.
it can be the directors of the company.
Mhm.
You just designate some time, say even
Mhm.
15 minutes or 30 minutes.
Mhm.
Let call the perpetrator, tell the
Mhm.
accused, now explain why
Mhm.
give us a reason why your contract should not be terminated, so that if
Mm.
I then have to give my explanation, and you know,
Mhm.
such meetings are normally best if they are minuted, so that minutes are going to be recorded, my
Mhm.
sentiments are going to be recorded, even if you know at the back of your mind that you don't want to work with Perry anymore.
Mhm.
Perry is just a nuisance in the office.
Mm.
You
Mm.
accord me that opportunity, and then at the end of it all, dismiss me. Give me my
Mm.
dues, dismiss me. I'm telling you, nothing will happen to you. So, more often than not, what typically happens is there is normally a disconnect between the human resources department and the
Mhm.
legal department, because a lot of
Mm.
places, people just make an assumption that legal department deals with maybe just with the strictly the operations as pertains
Mm.
what the company does, and then
Yes.
we tend to forget about the human resources department. So these two departments have to work in sync
Mm.
for the organization to minimize its risk in as far as litigation is concerned, because litigation is a liability and it is
Yes.
very expensive for a company. And then quickly, I'll just to the modalities. The way
Mm.
the first speaker rightly put it, a
Yes.
contract of employment is
Mhm.
basically governed by three statutes. We
Mhm.
have the law of contract, we
Mhm.
have the Constitution of Kenya, And
Mhm.
then finally we have the Employment Act, the Constitution, and then the Law of Contract Act. So that
Mhm.
as you draw your contract of employment, you
Mhm.
have to understand that there are some clauses that
Mhm.
in as much as the Constitution and the Law of Contract has given us freedom to
Mhm.
dictate terms of a contract, we have
Yes.
to make sure that the said terms are not inconsistent with
Yes.
the existing laws. So
Okay.
that, for example, what I mean when I say that is uh, now the Employment Act has given a guideline on under
Mhm.
Section 35 on how termination are supposed to be done, depending
Mhm.
on the nature of your engagement, so that as we draw our contract of employment, I
Mhm.
cannot be working for you for a month and then you're
Mhm.
saying that you want for me to terminate or for you to terminate the contract. I have to
Mhm.
give you a 1 week's notice. You see, that is
Mhm.
inconsistent with what the what the Employment Act is saying. So that quickly, I'll just dash through the points.
Mhm.
If the contract, your terms of engagement
Yes.
stipulates that you're paid on a monthly basis, 30
Yes.
day no, after 30 days, you're
Mhm.
supposed to give the employer, it is a reciprocal. The employer or the employee has to
Yes.
give the other a 30-day notice
Mm.
before termination of the contract,
Mhm.
so that if you're working for a company, you're paid after a month. That is what you're supposed to consider, so that you just can't wake up. It's if the employer can actually sue you
Yes.
if you were to terminate the contract. Me as an employee, I wake up in the morning and then I tell my employer, by the way, I'm not reporting to the office today. Our
Mhm.
relationship is done. You see,
Mhm.
now that I'll have breached the provisions of Section 35 of the Employment Act, and that will mean then I'll be liable. I'll have to pay damages as the employer may claim from the court. And then number
Okay.
two, if for example you're there working on a daily basis, because you have seen such cases.
Mhm.
A majority of the time, that happens in the sort of informal or for the semi-skilled work group. If
Mhm.
you're paid on a daily basis, then your responsibility then shifts from a 30-day to a
Mhm.
daily basis, so that if I want to terminate your contract, I can
Mhm.
tell you now as an employer, Bwana so and so, tomorrow don't report to work. There's no work. If I pay
Mhm.
you on a weekly basis, if I pay you on a by monthly basis, the rules apply. I give you a
Mhm.
2 week notice, we terminate your agreement
Mhm.
of engagement of now the terms of your engagement with the company.
Okay.
So now you'll the other fundamental thing that now people will wonder, because as we rightly put it, when you terminate a contract of employment, there are so
Yes.
many implications. They are emotional,
Mhm.
financial, and psychological in nature. So
Yes.
let us quickly, just in under 30 seconds, look at what for example, what the Employment Act says. Because when we are dealing with the Employment Act, we are dealing with the issues of money. So,
Yes.
what am I supposed to pay you? Because
Mhm.
now you've said that I don't want to work with Perry anymore. You've we have gone through the hearing. I'm assuming I just come to work intoxicated. I come to
Mhm.
work late, and after the resolution, it has been unanimously heard that I'm supposed to be dismissed. So what does the employer do? So the employer is supposed, if you don't want me to work, I may be under suspension. So you'll
Yes.
definitely give me salary in lieu of that notice. If, for example, you've told me pending the hearing and determination of the meeting or of the tribunal in the office, you won't
Yeah.
report to work. You just stay at home so that you'll give me my salary. That is what the court has, what the act has said. And
Mm.
then if there are any other accruals, you will have to make sure that all my all your statutory obligations in as far as the employer is supposed to meet they all have to be met, so that
Mm-hmm.
once now you do that, you can see you'll only be liable for payment of that the 1 month's notice that I've not
Mm-hmm.
reported to work. You see, so you found me guilty. It's in the middle of the month. It's been 2 weeks. I've not come to the office. So what do we do? You've told
Mm.
me to go at home. I'm at home. So the best the company will do is will say, after the resolution of the board, we have decided that we no longer wish to work with you based on your misconduct. With that, the company will be vindicated. There won't be any dispute, any litigation.
Okay, okay. Wow.
Yes,
Perry, you have
yes,
really brought it up. You have brought it well.
yes,
The issues regarding the legal implications of terminating an employment contract. I like the fact that you have brought in clarity for
yes,
us and for our viewers to understand that there are three fundamental laws that affect the law of contract. You know, when the employment contract between an employee
yes,
and employer. There's the law of
yes,
contract, the Constitution of Kenya, and the Employment
yes,
Act. You know,
yes,
and now,
yes.
and you have even explained, you have even anticipated what I was about to ask, the procedure to terminate
Yes,
an employment contract. Martha,
yes,
let me hear your perspective. You've heard what Perry has really brought the legal aspect. And Perry, I like the fact that you've said something that we always discuss here in this podcast, especially when it comes to legal issues, that
yes,
the HR department and the legal department, if there is one in the
yes,
company, have to work
yes,
in sync. We have had Martha
yes.
say many times she consults legal minds
Lawyers,
before,
yes,
yes, before she makes a step. So Martha,
yes.
Perry has told us the procedures to terminate a contract. Let me hear from you, from an employer, or from an employee, from a what do you call it, a HR perspective. What's your take on the issue of terminating a contract? Somebody has come drunk. Somebody has absconded sick. Yeah, he has decided, you know what, guys, I am so important to this company. I can afford to take leave of absence without having to do it for you people. There's nothing you will do. There's nothing you can do. I am the IT guru
Exactly,
here. Yeah,
exactly. Nothing
I
will
am,
work if I'm not here.
yeah. So please give me 2 days to take in the fresh air of Amboseli, for example. Nikirudi kazi tutaendelea. So Martha,
Tutaendelea.
yeah,
Yeah.
Martha, tell us
So,
from a HR perspective, what do you think?
right now I feel very inadequate in this subject because I'm just taking notes as Perry talks.
Mm.
And I really appreciate, and I'm thinking during our final podcast of this, among the panelists, Perry can come in again and just educate the HR. I have a
Mm.
lot of people in the HR forum who log in, and this will be very beneficial for them if Perry was
Mm.
to come when we have a longer session. But
Definitely.
yeah, on the ground, to answer the question, Tony, on the ground, you will get a HR person will get a call from a manager.
Hmm.
I do not want Tony here today.
Come on.
He comes to work smelling drunk. He's smelling alcohol. He's an alcoholic.
Mm.
And so you are trying to think, we have a procedure. We don't
Mm.
just call Tony and tell Tony, get out of our office. But on
Yes,
the
Exactly.
ground, the managers are busy. So all these things that come in, they kind of come to interrupt what we
Mm.
are trying to do and achieve.
Mm.
And I always understand their frustration,
Hmm.
but as you have heard clearly, there is a procedure, and this procedure actually
Mm.
is defined in the law.
Mm.
And Perry has brought out very
Yes.
clearly the three areas of employment where you'll find what you need to do. And it's very
Mm.
Yes.
important. You just
Ye-
go and check what the law says. What does the Constitution say? And
Yes.
mostly, does the contract with this person say? And then,
Mm.
and the
Yes.
HR manual.
Mm-hmm.
And you'll find
Yes.
the HR manual in the organization will be aligned to what the law and the Constitution is saying. So even the
Yes.
employment contract should also be
Yes.
aligned to that, because
Mm-hmm.
then the employee have signed to some terms and conditions, and those are the agreements that he agreed he will, the boundaries of
Mm-hmm.
working within that organization.
Yes.
So
Yes.
the and like for where I work, we want to continually sensitize staff on these things. And
Mm-hmm.
if there is violation, then what is this procedure we are going to take? So the staff also
Mm.
needs to understand the procedure. And one of the
Mm.
things is what Perry has said. There has to be a notice to show cause why we
Mm-hmm.
should continue or not continue working with you. There is this allegation against you, Tony. What
Mm-hmm.
are you
Mm,
saying?
yes.
What
Mm-hmm.
is your
Yes.
side of the story? Because a story
Yes.
always has two sides. If you
True.
Yes.
listen to one side, then you're going to do something we call discrimination. You'll
Mm.
discriminate
Exactly.
against that employee, and then if you
Exactly.
sack them without going through the procedure, the court will call it, I heard him call it unfair
And fair
termination.
termination.
Yeah.
Mm.
Yes.
And that's where
Yes.
you find, like, we think courts are for the employee, is
Mm-hmm.
because there's a lot of mishandling of staff.
Yes.
Mm. Correct.
Yes.
And then we have had, it's not necessarily what you have done, Tony, is the procedure
The procedure.
Mm-hmm.
Yes.
we have used
Yes.
to take you out.
Yes.
So you
Yes.
may have come drunk and but
Yes.
what procedure did we use? So that's what the
Yes.
court now I have understood. That's what the court checks.
Mm-hmm.
Yes.
So, and I can even bring you to court and you're drunk. And I'm trying to tell
Yes.
them, look,
Yes.
even today,
It's
look at the
true.
way
You
he is. But what procedure have I used
exactly.
to
Mm.
get you out? And
Uh-huh.
one
Yes.
of the things that we have to do is for that staff to show cause. Why?
Mm-hmm.
Yes.
Mm-hmm.
Yes.
And when we read the notice to show cause and we see there is a case,
Yes.
then we go through the disciplinary procedure as it has been
Yes.
outlined by the law.
Yes.
Yes.
And some of the issues, especially for what do we call the one the instance dismissals, then
Mm-hmm.
it won't go through the process of warning one, warning two.
Exactly. The
It goes to
summary
straight
dismissal.
to
Yes.
Summary.
procedure number 5,
Yes.
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 where
Yes.
so
That is true. Yeah.
we hear you,
Hmm.
Yes.
and there's a procedure in our organization. We have a committee. It's not just the
Mm-hmm.
HR who does that.
Mm.
We
Exactly.
have a committee that is set to
Mm-hmm.
do the investigation, and during the
Yes.
investigation, most likely that employee will be on. They will have to take some leave. We call it
Yes.
Mm.
suspension.
Suspension.
But
Yes.
that's a
Yes.
paid suspension. So you
Mm-hmm.
can't say
Yes.
that that person was not working and then you don't pay. No, it's a paid
Mm.
suspension. We give it
Yes.
like 15 days
Mm-hmm.
Yes.
as we do investigations.
Yes.
Mm-hmm.
And then we call them and we kind of, maybe in the investigations, then we have found some people who can help us with this case, who we call witnesses.
Mm-hmm.
And
Exactly.
we have this case. And once we go through that process and someone has been found, like, really they did this, then
Mm-hmm.
Yeah.
we give our recommendations
Mm-hmm.
to the
Yes.
executive.
Mm.
And for this
Yes.
instance that we have found this person is guilty, we give the recommendation of termination. And if the
Yes.
Mm.
termination letter is issued, there's a condition we put there that the employee has 7 days to appeal to the executive
Yes.
director.
Yes.
Mm-hmm.
And if they
That
still
is true.
feel aggrieved, they can appeal. And then
Mm-hmm.
the executive director will still call for a hearing to hear why they are saying they are not guilty. So if
Mm-hmm.
the executive director can uphold that decision, or
Yes.
they can reinstate the person. So that's the
Ah.
Exactly.
procedure we use. Yeah. I
Mm-hmm.
Exactly.
so where I
Exactly.
work, so I've put it
Yeah,
here
that is
because the
good, by
lawyer
the
is
way.
here. He can tell you where are the gaps in that procedure. Thank
Oh
you.
yeah, and just to add on that, which is very very good, by the way.
Mm-hmm.
As you call the employee who who is now undergoing the disciplinary the process, you
Yes.
have to ensure so that we can all say that there was no discrimination. He was given a fair opportunity. You
Yes.
give him the chance of selecting anyone, because the law says he can decide and take his fellow employee. I'm your fellow advocate, I'm your fellow IT guy. I want
Yes.
you to come with me in the meeting. I want you
Mm-hmm.
to be my side, someone who is going to help me out. Not really argue out the case on my behalf, but I just want to feel comfortable, because you can imagine you're seated in a meeting that and you're surrounded with the entire management, and you're on your own. I'm sure some people will
Mm.
really feel intimidated. You'll feel as though
Yes.
you're in a shark tank, literally. But if you have someone who is your fellow employee, even if they just decide and keep quiet, but they're just there to support you emotionally, psychologically, and even during the investigation, because there may be issues about, say, as you've rightly put it, Thuku, it may be an IT guy. There are some there are data that has now been misplaced, or there's data that has now leaked out. We want to
Mm-hmm.
find what really happened, so that if I'm to say something, maybe the IT guy, the person that I've brought as my side assistant in the meeting, will
Mm-hmm.
really help shed light, so that if there is anything that needs to be added or needs to be clarified, he can do that, so that you don't go and tell the court I was unfairly discriminated because they just called me to the committee. I was not able to, they told me not to come with anyone. So they just accused me. They just did what? Because even that person that I come with can actually
Mm-hmm.
turn out to be a good witness. Because when you turn down, as you write the minutes, you will write the attendances. So that if I'm to sue you, you'll use that. So that you'll say, Perry was summoned and he was given an opportunity to come with his fellow advocate for the meeting,
Mm-hmm.
for the disciplinary proceedings, and throughout the disciplinary proceedings, he was well represented. You see, because in some
Mm-hmm.
instances, you may even it may even call, depending on your policies, you may have to come with literally an advocate or someone who knows the interpretation, the application of the law. So it just varies, and that is actually good. And we should really purpose to ensure that we spread the word. Because when we come to court, we always feel really sad and concerned when you see big companies, very very
Mm.
big companies in Kenya that are not even supposed to be in the employment. You come and litigate over other issues,
Mm.
trademarks, but I don't expect to see a very big company which has been who has been sued by say a gatekeeper or a cleaner.
Mm.
Yes.
Mm.
And you're
Mm.
there, you have to hire an advocate to go and represent you there. Yet there's something that could have been done in the back. So that
Mm.
basically, as a Agimba and Associates, we
Yes.
always advise companies, if you know you're not in a position at the moment, because forming such forming such departments may be quite expensive. We do
Yes.
understand. The
Yes.
best you can do is to take refresher and continuous development courses. You get
Mm-hmm.
advocates for a couple of hours. You sit
Mm.
down with them, give them your contract of employment for them to
Yes.
review. They
Mm-hmm.
can identify gaps that
Mm-hmm.
you as an HR specialist cannot see. They can
Mm-hmm.
look at at your policies, because there are
Mm-hmm.
policies that have been put into place. For example, you know your workplace has to be sanitary. It has to be clean.
Mm-hmm.
It has to be occupational hazard, because there's that element, so that if
Yes.
there is a fire in the office, how
Yes.
protected are your employees? Because you know I can equally sue you on that ground. If I come
Mm-hmm.
and say that, you see, we don't have fire extinguishers, I'm there working in a factory, you're not giving us enough and adequate protective boots, you're not giving us gloves, so you see, you're
Mm-hmm.
exposing us to injuries
Yes.
and other harm. So that
Mm-hmm.
when you just have that opportunity, let people go, professionals go through your contracts, we go
Mm-hmm.
through your policies, we
Yes.
identify what can be changed, because even advocates and the uh, other just experts in employment law, they can
Yes.
even talk to the employees, because the
Mm-hmm.
employees, they may be there thinking, they may have their own notion of
Mm-hmm.
how their relationship between the employer and the employee is supposed to be governed. So you're there,
Mm-hmm.
you're shouting, why are these people not doing this and this? I thought we were supposed to have these in the office. No.
Yes.
So that if you sit together, we can all bring the employer and the employee on the same wavelength, so that
Mm-hmm.
with that you'll find that the existing relationship that is there is going to be beneficial to both the employer and the employee. So actually, that's actually a point to note,
Thank you.
over and
Thank you.
above bringing, yes,
Oh,
having a disciplinary
okay, Tony, I wanted to
Definitely.
add something to tell
Yes.
what Terry has said, just a few seconds.
Mm.
Yeah,
yes.
thanks, Tori. I had left out that part of asking, giving the employee the opportunity to be accompanied by someone. And
Yes.
for some reason, I
Mm.
find staff, I don't know whether they feel confident about their case or
Mm-hmm,
they feel
mm-hmm,
like the person they will bring will not be on their side. So you'll find
mm-hmm,
most of the time they will not
mm-hmm,
come. The cases I've handled, they don't come with someone. But
mm-hmm,
I know a case I handled earlier, in some organization I worked. It was a
mm-hmm,
case of sexual harassment,
Mm.
mm-hmm,
and it really helped that person to come with another person, because
mm-hmm,
Mm.
what we learned in that committee was that this person who is claiming to be sexually harassed had been
Mm.
friends with this person for many years.
yes,
Exactly.
People see
Mm.
them
exactly,
holding hands when they are
yes,
going to field trips, they go together. When I joined
yes.
that organization, I thought even they were an item. It's
Mm.
Okay.
in that meeting
Yes.
that I learned that they were friends. They were not
Exactly.
what that item I mean.
Mm.
And
Uh-huh.
so it really helped for a that person who came and said, no, it will be so unfair if we dismiss this guy because these people have been friends like for over 5 years. In fact,
Mm.
everyone was
Yes.
thinking their boyfriend, girlfriend. So
Okay.
Mm.
that changed that case
Mhm.
from
Yes.
from termination
Mm.
to
Yes.
warning to something else.
Yes.
Mm.
And it
Yes.
was at the
Yes.
strength of this person they brought. So it's very important for employees to know, it is so important to
Yes.
come with someone who has more information than we could
Mm.
Yes.
have gotten even in the investigations.
Okay.
Thank you
Exactly.
very much. And I've also noted that part, Terry, that it is okay to invite a labor lawyer to
Mm.
talk
Yes.
so that they come and they bridge this gap between employee and employer. So
Yes.
organizations seem like they're just putting rules. So if
Mm.
these
Yes.
things are unpacked when everyone is there by
Yes.
someone
Exactly.
who is
Exactly.
really understands these things, then the organization will be harmonious to work. Yeah, thank
Wow.
you.
Yes.
Mm.
Wow.
Yes.
Wow. Wow.
Yes.
Man, today we have learned a lot. As Mother was saying, when Mother was speaking, I was jotting notes. When Perry was speaking, I was jotting notes because I'm also downloading, and
True.
and I'm imagining our viewers and listeners. You must have
Yes.
found this to be a very educative program, very educative session that you've had today. That Contract termination, there is, from what we are learning, if I will speak on behalf of those who are listening to us, who are neither HR or legal experts, but who you
Yes.
are, you're an entrepreneur, you're a business person, you're a manager, you're running a business, and here you're wondering this topic of contract termination. You're thinking, no, we can't do this thing. The law is skewed. Perry has told us today that it is about procedure. It's about the
Yes.
procedure that you go upon to do it.
Yes.
Martha has told us
Yes.
clearly that indeed contracts can be terminated because employees can decide today to resign. The employer can't force them unless there's a clause there preventing you from resigning for a number of years. Then people leave. Resignation is a form of termination. But now,
Yes.
where it is employer generated, whether it could be because of redundancies, could be in issues of the disciplinary, it could be whatever issues, the procedure that you follow to do it
Yes.
is key to making
Yes.
sure that you don't end up having litigation. And
Exactly.
Perry, thank you very much for giving us the option. For those
Yes.
of us who are listening, if you're a business person, you're running an SME, and you're wondering, okay, how do I go about this? Yes, I have a HR and our the contracts that we have signed with our employees, are they breaching law? Are they on the right side of the law? That
Yeah.
Perry has told us through their company, Agimba and Associate Advocates, that you can be able to get in touch with them, and for a few hours, so for whatever session of time that you'd want, to have your HR and the management and the employees go through the contract together to see where do they need to be worded differently, do they need to be, are there gaps there, so that from both an employer and employee perspective there is harmony. And Perry, I like the fact that you brought in the idea that
Yeah.
let's not have litigation regarding wrongful, yeah,
Wrongful
yeah,
termination.
yeah, wrongful
Yes.
termination, things that are so simple to sort. Yeah,
Yes.
there could be other bigger things, the way you said, with issues with patents and trademarks. Now,
Yes.
now
Yes.
we're talking about meat and bones, the meat of corporate, corporate world, in the world of corporate.
Exactly.
Now, our time has really gone. I mean, today, Martha and Perry, you have really brought it mpaka imepitisha hata ile wakati tunakuanga nayo. So I've enjoyed myself, and I believe our viewers and listeners have also enjoyed themselves. Now, we've come to the close of our podcast today, and you can always get in touch with us here at our podcast using the contacts at the bottom of your screen, via WhatsApp, via LinkedIn, via YouTube, via Facebook, and
Yeah.
also through our website, www.rmconsultants.co.ke. And now, the final thing that I would want to bring to our viewers and listeners, if you are having challenges, you're wondering now, that fellow comes to the work drunk, I need to get rid of them. Oh, that staff, he's been accused, but he's so slippery. He's so slippery. He has been accused of sexual harassment. Because those things happen. And you're wondering, okay,
Yes.
I need HR advisory. I need legal advisory. How do I handle this? You can always get in touch with us here at RM Consultants. And through us, we can also link you up with people like Martha and Perry at Agimba and Associate Advocates to help you sort out the knotty issues of how to terminate your contract and many other HR related issues. We would love to come in and partner with you as a business person to to be able to navigate these funny issues that, as Perry has told us, they are really very simple to sort if only you follow procedure. Well, thank you, folks. Thank you for taking time to join us this Saturday morning. As Martha said, we would love to have it would be good to discuss this thing at a longer period of time, without being worried about the time that, the 30, 45 minutes that we normally do the podcast. And the next weekend, we will definitely be having a webcast, a webinar where we will conclude issues regarding contracts, contracts, their formation, their termination, the renegotiation, all those aspects. On next week, on the 26th of February, we will have a webinar where we can discuss these matters at length. So send in your questions, send in your comments. Martha, you said you're going to bring in a few of your HR peers. Kindly bring them in so that if Perry or anyone else at Agimba and Associate Advocates are with us, then we can hear, we can get a 360 view,
Yes.
360 view regarding contracts and everything in them. But having said that, we have come to the end of our podcast. We want to thank you, our viewers and our listeners, for logging in. Next week from 9 a.m., we'll be here to discuss further these matters. So until then, take care, be blessed, and see you then. Thank you very much.